All right, good evening. Welcome to the Thursday, October 10th, 2013 meeting of the City of Lowell License Commission. Was the meeting posted? Yes. Okay. We're going to skip number 1 on the agenda and go to number 2.
Commission consider review and approval of the minutes for the September 26th meeting.
Move approval.
Second.
All those in favor say aye.
Aye.
So moved.
Commission will now take up applications for special one-day for beer and wine only, malt beverages and wine only, or either one. Laura Poland of the Merrimack Repertory Theater for the Harvest Wine and Beer Tasting for Wednesday, October 23rd, 6 p.m. to 8:30 p.m. at the Merrimack Repertory Theater Rehearsal Hall at 132 Warren Street. Emily Marks of the 127 Global Inc. for the Charity Ball 2013, Saturday, October 19th, from 7:30 p.m. to 11:30 p.m. at Mill Number 5, the 4th floor at 250 Jackson Street. Christine Chuck Trainer of Aramark for the University of Massachusetts Lowell Softball Alumni Reunion Reception, Saturday, October 12th, from 6 p.m. to 8 p.m. at the University of Massachusetts Lowell Mahoney Gym, 870 Broadway. And Jeffrey Prescott of the Merrimack Repertory Theater, the theatrical performances by the Merrimack Repertory Theater starting with October the 24th and running through until November the 17th, 2013. This will be for the concession sales and service for 45 minutes prior to the performance of that given day and during the 15-minute intermission, all of which will take place at Liberty Hall and 50 East Merrimack Street.
Introduce yourselves for the record.
Laura Poland from Merrimack Repertory Theater.
Emily Marks for 127 Global.
And Jeffrey Prescott from Merrimack Repertory Theater.
Okay. How many of you had a license before here? 2. All right. For
3.
Oh, 3? 3. Okay. So just Emily is the only one that hasn't had the license. Just remember, the license is in your name. It's not in whatever entity you're representing. It's you. So you have complete control of who's being served, who's not being served. Make sure that you have the Lowell Police Department on call. Don't call 911, call the Lowell Police Department directly. And where are you getting the alcohol from?
Me, from Tutto Bene. They have some vendors that are supplying the alcohol.
Okay. So the Tutto Bene, that's the caterer? Okay.
It's a wine cellar in Lowell.
A wine cellar in Lowell, okay. Supposed to get them from a certified distributor, right?
Well, state regulation would require that licensees obtain their alcohol beverages through a licensed distributor through the state or other state licensee by the Alcoholic Beverages Control Commission as your source. It's not acceptable to purchase from a package store or any retail store that has alcohol for sale to the public.
Okay, they're actually donating the wine, if that makes a difference.
You say you're going through other distributors as well as Tutto Bene?
Tutto Bene is making all the arrangements with the vendors, as far as I understand.
When is this?
So this is for October 19th.
Yes.
Well, you have to follow state law. So I want to make sure that that wine, Tutto Bene may be donating it, but make sure that they're obtaining it from a distributor and that you're not getting it directly from Tutto Bene. The distributor should be delivering it to, is it 205, 250 Jackson Street. Okay. That's who should be. So make sure that arrangement takes place. I don't want to cause you guys any problems. I just want you to do it correctly.
Okay, thank you.
Okay.
Yeah, Ms. Poland, can you describe physically the building at 132 Warren Street?
It's our administration and the rehearsal hall. So we are using the rehearsal hall for the event space.
Yeah.
Did I answer the question? I'm
No.
sorry.
But what's the building look like? If I was
Oh,
to
what is the-
drive down Warren
Oh,
Street,
sorry.
what would it look like?
It is a small brick building. It's also called Bagshaw Mills. It has condos and I think it's 2 stories tall.
2 stories tall. Thank you.
Everything in line, right? Everything else is in line?
I'm sorry.
Is everything else in line? All the paperwork, everything's good?
Yes, I know Mr. Prescott has been before the commission probably about a year ago in a similar capacity, taking the responsibility for this next series of performances. And Christine, we're well acquainted with her. She works with Aramark, so that's, she's been before the commissions.
I'll make a motion to approve. All those in favor, say aye.
Aye.
So moved. Good luck, guys.
Thank you.
Thank you very much.
Just some update for the License Commission to ratify. At our last regular meeting, which was September 26th, before the commission was Mr. Davey Borba, who represents and is a corporate officer for Commonwealth Auto Sales and Repair. He's the president, being an applicant for a used car dealer's license. And the application there was some question as to the proper numbered address for the premises. It's presently licensed, or had been licensed at the time, to Middlesex Auto Sales, and it was listed as number 639 Rogers Street. My initial contact with the city engineer's office after the License Commission had some questions about whether 639 was the proper number, or should it be 645 Rogers Street, Lot B. And initially it was my understanding, and thought I had confirmed that with the city engineer, that there was no such record of 639 Rogers Street. And when this information was brought to Mr. Borba's attention by the commission at our meeting on September 26th, it was the commission's intent to grant the license, but that the licensee, Mr. Borba, Davey Borba, would seek to have the correction on the lease agreement such that it would read 645 Rogers Street, Lot B. Apparently, after the last meeting, Mr. Borba contacted the lessee, Richard Daggett, who had been leasing from JEG Realty Trust. Jonathan Gerber is the trustee. And they had decided to come to City Hall and follow up on the matter of whether 639 could remain as the numbered address for this particular lot. And come to find out, having Mr. Daggett and Mr. Gerber go before the city engineer's office, speak to another person that I had not initially contacted on the matter, who confirmed their belief, Mr. Gerber's belief, the trustee of the property owner, that it should read 639 Rogers Street, and had been a subdivision. So that initially it was 645 Rogers Street, Lot A, Lot B. There had been a subdivision, and it had been filed with the city engineer's office, had also been submitted to the Registry of Deeds. The question as to whether it was, in my mind, I should say, it was whether it was 639 was properly recorded. Apparently it had been, and the city engineer's office had recognized it as such, and as pointed out, it was pointed out to me by one of the city engineers that 645 was for the business which is known as Jiffy Lube, and that 639, which was formerly known as 645 Rogers Street, Lot B, 639 would be the correct number. The assessor's office has 639 Rogers Street for this open lot, which has been used as a used car dealer's site for over 10 years, actually maybe 15, 20 years.
So we can issue the license.
I did issue the license. But I wish the commission ratified the change of their action that I took upon the word and record, and I think I forwarded to your attention information from the city engineer's office since our last meeting to indicate that it was and is 639 Rogers Street, and that we can proceed with, and I proceeded to issue that license to Mr. Borba for Commonwealth Auto Sales as 639, and I wish the commission ratified.
I second.
All those in favor say aye. Aye. So moved. Thank you.
Number 5 on our agenda, we have a letter, a request from Mr. Ralph Tucci Sr., who is the president of Lowell Used Auto Sales, Inc., at 108 Tanner Street. The letter that the office received is dated October 3rd, 2013. And in this communication, Mr. Tucci is requesting, on behalf of Lowell Used Auto Parts, Inc., that the site known as the premises for a Class 3 licensed used car junk held by Lowell Used Auto Parts, which includes 108 Tanner Street, and also across the street it includes 121 Tanner Street. Mr. Tucci is requesting that that lot, 121 Tanner Street, be removed from the Class 3 license presently in his possession, so that he may have a possible tenant in the foreseeable future apply for a Class 2 license for that lot. I have copies of, from this tax title office, City Hall, indicating that Mr. Tucci presently is in a payment plan with the City of Lowell for several more parcels of property that he has direct interest in, one of which is 121 Tanner Street. So apparently that agreement is in good stead, puts Mr. Tucci in good stead as far as any possible change he may wish to make. I just want the commission to be aware of, and Mr. Tucci is here before you now, is that the Class 3 type license, used car junk, is a very specialized license. It's very unique, and there's only 5 businesses that hold such a license in the city of Lowell. And a lot has to do with zoning, a lot has to do with the environmental issues.
Is a Class 3 license more stringent than a Class 2 license?
Absolutely, in terms of maintenance and storage and use. And it's not something that can readily be, as far as License Commission acting on an application for a Class 3 license, there has to be more consideration given to the city's zoning ordinance, not only city's zoning ordinance, but state environmental laws and regulations. In conversation with Mr. Tucci, it's my understanding he recognizes that the possibility that if the commission was to take action to approve an amendment to his license so that 121 Tanner Street is no longer part of the licensed premises of the used car junk, Class 3, it's possible under the city's current zoning ordinance, and I would defer to the city's building commissioner, of course, the law department, on the possibility of ever getting that back as a Class 3 location.
You're aware of that, Mr. Tucci?
Yes, I am, yeah.
So he wants a less stringent license. He understands, you've had a Class 2 license before.
Yes, I have,
You understand the
yeah.
ramifications of exchanging the license,
Yeah, but,
and you want to go forward with that.
yeah, because this way here, I could do something with the property. I could rent it out for a used car load, I could sell it. You know, I mean, I can't sell it as a Class 3 license. So it's, get some rental income come in so I can pay my
So you
taxes.
can pay the taxes.
Yeah, it's
Make a
pretty
motion to
simple.
approve. Why not?
Second, unless you want to say something?
Got a question.
Yes.
What are the remediation issues, environmental remediation issues between a Class 3 and a Class 2 license?
Well, that would be something I'd have to look to the Office of Developmental Services to see what, if anything, they may want to look at beyond just the fact that this Class 3 license could be amended such that it would delete from the license 121 and the use and other possible uses, be it for Class 2, for whether generally a Class 2 licensee is going to have outside sales and storage. It's going to be accessible to the public for the interested.
Right. I'm in favor of this, but I just want to make sure that if there are any environmental remediation issues that we haven't pinned down now, rather than there being confusion later on. And in my ignorance, I think I want to have us take a look at that. I defer to you, Mr. Chairman.
And I've had used cars on there for like 20 years. I haven't even used it as Class 3 license for 20 years. I've owned the property for 30.
Ryan, just for clarification, the Class 3, you said there were additional storage. Now, what are we talking about storage here?
Well, generally, a Class 3 can have parts of vehicles.
Yeah.
You can dismantle vehicles on a site that's licensed for Class 3.
Yeah.
I don't know, I have no idea whether at 121 Tanner Street, Mr. Tucci, at any point in time, since he's held the license for 30 years, thereabouts,
Yeah.
would have dismantled any vehicles, any spillage of any oil or anything of that nature. So that's,
But as a board, I mean, if it's environmental, it's just gonna go to a, to a different department. For us, we can.
Yeah, it would
He
be
just,
beyond
he doesn't
this-
want his Class 3, he wants a Class 2.
it's, the thing is, I would suggest that if it's one thing to say to Mr. Tucci, yeah, we'll remove it. Possibility of having it being a site for a Class 2 licensee is another matter
Right.
that may come up with the,
Well, you haven't entered into a purchase and sale agreement yet, or a lease agreement or anything.
No, well, I have somebody that does want to lease it off me. Yes, I do.
Okay,
Yeah,
but
he
they're
wants
gonna have to
rent it.
apply for that Class 2
Oh,
license.
yes, yeah. for Class
So
2
why don't we
license.
deal with the Class 3 converting to the Class 2 when they apply? If someone actually applies for that license, then we can find out whether any environmental remediation needs to take place. We don't need to take any action on it right now, but
Right.
we will look favorable.
I would suggest, if I can, just that you would file an application with respect to deleting from the Class 3 license 121 Tanner Street as amendment to your license.
Right.
Subsequent to that, the commission can act on that, if they wish, and then any possible lease that you may enter into with a potential tenant for 121 as an applicant for Class 2 would be something the commission could defer to the law department, or the Office of Developmental Services.
If I don't want to give up my Class 3 license if I'm not going to get a Class 2 license. It's pretty
Right.
simple.
Right,
You know what I mean? You know what I mean? It's like, like,
Do you have
Oranges and
cars
apples.
stored on the lot right now?
pardon?
Do you have cars or parts stored on the
I
lot
have
now?
no parts stored, well, some doors part, but no mechanical parts at all. It's been a car lot for 20 years, selling used cars, because my license has that. I have the right to sell used cars, junk cars, the best license you can have. This is like a $1 billion Class 3 license, and I'm trading in for a Class 2 license. You know, if I was to sell it, then, they'd have to go to the 21E test and all that there. I mean, it has nothing to do with the license. It's just, I'm giving up something for something smaller. People think I'm crazy for doing it. Even Ryan said I shouldn't be doing it. But I am. It's just, because I can't have him go in there with a Class 3 license, sell used cars. I can't rent it out. I don't want them getting a Class 3 license and selling parts. Even if I was to sell the property, I wouldn't want them to have a Class 3 license, because they're hurting my business across the street. So it's just.
Yeah, I think we should just,
Yeah.
just put it in the file, and
Yeah.
when you get a prospective lessee, you come back to us,
Yeah.
okay?
Yeah, well,
So at that time, you would file an application to amend your license, deleting 121. The other person applying for the Class 2 license would just include that as part of their description. Is that understandable?
yeah, so, yeah.
Okay, so,
I might even want a Class 2 license there.
It's just a little cleaner, that's all.
Yeah, yeah, but I want to, I might want to apply for a
Yeah,
Class 2
then you
license.
can do that.
Yeah,
Do that and then be transferred?
yeah.
All right, good luck.
Thanks.
Thank you.
okay. Number 6 on our agenda is a communication that the Executive Secretary received from a Deputy Chief Mark McGuan, Lowell Fire Prevention Office, dated October 2nd, 2013, citing management at Caballero's Restaurant, 573 Lawrence Street, and an issue with respect to the fire alarm system and its maintenance. I was out of the office last week, and when this email came in, so it wasn't until Monday morning that I saw that Deputy Chief McGuan had apparently had some issue with the management at Caballero's Restaurant, and obviously can be a serious matter.
Yeah, I
And-
think we should have him come in. I think we should have him come in.
Okay.
Yeah, because if he's not complying with the fire department and he disabled the system and,
I think we had a similar type of situation up here on
Right.
Central Street
Right.
with one of our licensees.
and I'm sure he'll resolve it before he comes in, but if we can just check with him when he comes in.
I don't think we do we?
I'll make a motion that we have him come in the next meeting. All those in favor say aye.
Aye.
Aye, so moved.
And last but not least, is just a communication from the Law Office of DeMarcus. Last August, they had set the communication that 99 Restaurant would be closing down for about a 5-day period. This time, October, this week, but apparently management of the company has decided to hold off on any closing till next year.
No, you don't have to. Yeah, adjourn when you guys are done. All right, I have to recuse myself.
Okay. Brian, number one.
I already got a copy, Ryan.
We're going to do DY, E and Y first. Oh, let's do DY.
Commission will now take up matter to do with a hearing on the allegations as charged by Deborah Friedel, the interim superintendent of police. Package store licensees that failed compliance checks last spring. The Lowell Police Special Investigations had conducted a check of these various licensees. An underage person, under their supervision, was asked to go into a store and seek if they could find out if they could purchase a beverage, and if the management would ask for identification. Several of our licensees failed that compliance check. The compliance check conducted on April the 11th, 2013. Commission will now hear the matter to do with DNY Corp., doing business as Jerry's Food Store, number 2, 207 University Avenue. Bhupender Patel, manager.
If you could introduce yourself for the record.
Good evening, Commissioners. Brendan McMahon on behalf of Mr. Bhupender Patel.
Captain Webb, can you give us a little recap here?
Mr. Commissioner, on April 11th of this year, detectives assigned to the Special Investigations Section under the command of Lieutenant Gollner were conducting compliance checks in various establishments in the city. They were assisted in these compliance checks by a 19-year-old male. The young man had no identification with him and only had money that had been provided to him by the detectives. At 6:30 p.m., the 19-year-old entered Jerry's Food Store at 207 University Avenue and purchased a 6-pack of Budweiser from a male clerk. The clerk did not ask for any identification. Lieutenant Gollner and Detective Desolitz entered the establishment and ID'd the clerk as the owner, Mr. Patel, and advised him of the violation.
Is that sufficient information?
It is, Mr. Commissioner.
Mr. Patel, can you expound upon this ID scanner machine for me, please?
first time, whatever I did, one day they came, I have ID, but I was, somehow something happened, and I was ready to go home, and I forgot that I have ID machine also I bought, last time.
I'm sorry, I think the question is, do you have an ID scanning machine?
ID machine I have.
Can I clarify that?
Please.
He has an ID scanning machine
Yeah.
that allows him to place it into the scanner, and it will say whether or not the identification is valid for purchase of alcohol. It is not currently connected to his cash register system. He does not have the software yet that would prevent someone from purchasing without the swipe. So although he does have the ability to check, it doesn't require the check to be confirmed prior to purchase.
But
When
it does confirm the ID. I mean, if I drive on to Hanscom Air Force Base, they shine a little machine at my ID card. It's not connected to anything, but they know it's a valid ID. So they have that capability, is that correct?
That is correct.
When was the ID scanner machine purchased?
I purchased last year,
When last year?
almost 2 years, I think. This year second, and this is third year, I think. I purchased.
All right, I'm sorry, I just having a difficult
I
time.
purchased almost now 3 years.
All right, so
Yeah.
3 years,
Yeah.
and Counselor, just so to clarify, he still hasn't set it up properly?
My understanding is that there is a program that you can use on the computer that would, when you scan in alcohol,
Yeah.
it requires the verification.
Yep.
My understanding is this particular machine that he has does not require the verification. It simply tells him whether or not it's a valid ID, independent of whether or not the sale is made. One of the things I have spoken with him about is obviously he needs to immediately implement and go get that program. When I met with him earlier this week, he's indicated his intention is to do so, to prevent sale without the scan.
So you're arguing that between the ID card and the cash register, this thing is not hooked up? But yet,
Correct.
my impression is that he never got the ID card to put in front of the scanner.
And absolutely, let me just make myself a little clear. We are not contesting at all that he failed to check the ID. I'm not suggesting that, or contesting any of the facts that the police have stated. In fact, he would admit today that he failed to check the ID. What I was simply doing was responding to the question of whether he had the technology in place. And he's attempting, or he has agreed, at least in conversation with me, that he will go get the program that allows the scanner to be connected to the cashier so that no purchase of alcohol could be made without that scanner.
I guess I don't want to beat a dead horse, Counselor, but
Yes.
prior to myself being on this board, Mr. Patel was here, I believe, in February,
Yes.
and I would have think that would have been a scare enough to make sure that software would have been implemented.
And I understand that, and I've
Yeah.
had that conversation with him, and I also explained to him that based on this, and as you can see, he has 2 of these on tonight's agenda. I indicated to him how serious it is. He understands the serious nature. He's not contesting either of these allegations and is looking for a chance. I indicated to him that, one, he should get the program set up. He was agreeable to do that. I also indicated to him that he should, be willing to allow whomever from the city, whether it's the commission or the police department, to come in and verify that, just to make sure that's working. I also contacted JBS, which is a company that you can pay them to come and do their own spot checks, private checks.
Yep.
He is willing to purchase that.
Can you give me a timetable on when this is all going to be complete?
I would think he'd
As
be able
soon
to
as
do it. I
possible.
would think he'd be able to do it within
As soon
30.
as possible, I'm going to do.
I would think within 30 days.
All right, why don't we make sure that's 30 days? Just to confirm, though, when Lieutenant Goldner asked you if you had passed it through the scanner, you were adamant that, yes, indeed, you did do that. Is that true or not true? Mr. Patel?
Yeah.
Okay. Cliff?
So we have a one-day suspension, right?
There's one day in abeyance.
All right.
A day of abeyance from February 2013.
So, for this case, it seems to me that A, we're interested in dealing with this, and B, we're interested in knowing whether or not things have been corrected. So, as Commissioner Dakota says, 30 days would be a good time to know. So I recommend that the day in abeyance be executed and 3 days be assessed, one held in abeyance. And we invite the license holder to return in 4 or 5 weeks' time to tell us how they've done.
All right, just for clarification, what that motion is that the 1 day that's being held in abeyance will be served?
It will be served.
All right, then with a 3-day suspension,
2 served.
2 served, so we're looking at a 3-day suspension with
Yes.
1 day held in abeyance. I'll second that motion. All in favor?
Say aye.
Aye.
And you wish to have the licensee return to you in 5 weeks, 4 to 5 weeks, or is?
Yes.
Let's do this, Ryan. Today's the 10th.
When's our next meeting in November? Not the next one, but the one after.
We're scheduled to meet November the 7th, and I believe it's the 21st of November.
We have no meeting on the 24th? October 24th, and then we go to
Oh, I'm
November
sorry.
7th, right?
Yes, you are scheduled to meet on October 24th,
Okay.
and then November the 7th,
Yeah.
and then the 21st of November.
21st of November sounds good to me.
Let's set the dates, though, for the suspension. The 3 days will be concurrent, October 25th, 26th, and 27th. Do we need a motion on that, Ryan, or on the days?
No.
No,
You
that's
got it.
okay.
Okay.
Now,
So
the practice will be that Mr. Patel will have to surrender that license, the beer and wine package store license, to the License Commission during the days of closure. There will be a sign issued to Mr. Patel in which he has to have posted that there will be no beer and wine sales during the 3 days of suspension. That any potential customer, because since it is a convenience store that offers other non-alcohol beverage items, and presumably he will remain open during this 3 days, no customer will be able to access the beer or the wine during those 3 days. So that, Mr. Patel, you will need to make special provisions to ensure that even if you're not there and you have an employee who's taking care of business, the customer can't even think about getting a six-pack.
Captain Webb, let me ask you, during these 3 days of suspension, is there a certain protocol that the police would do about checking upon something like this?
Yes, we notify all the officers of the suspension and ask them to make periodic checks. I also have a question on the 3-day suspension. Would the licensee be required to remove all the outside advertising on the building regarding alcohol sales?
Would we be
That
able to
is,
supply the sign? Can we supply the sign to put in the front door at that time?
Certainly, the sign that will be made available, and it will be conspicuous, and it has to be posted in a conspicuous spot so the general public will see it. But the beer signage that retail stores are prone to have, I think Captain Webb's question is something the board should maybe. It's up to you.
If there's a, in my mind, there's a question between the permanent signage and the temporary signage. And do you have any permanent signage for beer and wine?
I have permanent sign outside, yeah,
What's it like?
big one, big.
Captain Webb, what's been past practice?
I don't know if this issue has come up before. This is the type of license where it isn't a regular package store, as you said, it's a convenience store, but we found that some of these convenience stores have, in effect, become almost like package stores. Their main business seems to be beer and wine sales as opposed to the usual things that are found in a convenience store. And I think this may be the case with this licensee.
Attorney Regan, opinion on this and how we should go about this?
Honestly, I'm not familiar with the past practices on this. I would suggest that temporary, sale on Michelob kind of signs should be taken down so that the public isn't drawn into the store thinking they can buy something they can't. Permanent signs, obviously, if it's on the business sign itself, that shouldn't be removed for a 3-day period. But I would think any stores, any signs attached to the windows, it would be reasonable to ask that those be taken down for that period.
Can we make sure, Captain Webb, that that is in fact being done by the
Yes.
cruiser at that time, just
Yes,
for
we can
those
check
days?
that.
Okay.
Okay, let's make that in the form of a motion then, so that
Yeah.
make this official.
So we'll make a motion that all temporary signage be taken down during the period of suspension. Do we have a second? Second, all in favor? Aye. Just to make this a little bit cleaner, the motion for the suspension was the selling or delivering an alcoholic beverage to a person under 21 years of age in violation of Mass General Laws, Chapter 138, Section 34. Ryan, that. The next violation of 204 CMR, no licensee for the sale of alcoholic beverages shall permit any disorder, disturbance, or illegality of any kind to take place in one of the licensed premises. The licensee shall be responsible, therefore, whether present or not. I would ask that that be placed on file. I make a motion that that be placed on file. Do I have a second?
Second.
All in favor? Aye.
Commissioner, now proceed with the next complaint. This involves L&M Liquors, Inc.
Are we gonna go?
Do you want to
Let's
continue?
go, let's not let them wait. Why don't we go back to back on DNY Corp.? How's that?
So you want to take up the second one?
Yeah.
Okay. So now the commission will proceed with the date of compliance check conducted by the Lowell Police Special Investigations on May 2nd, 2013, in which at that time, DNY Corp., doing business as Jerry's Food Store Number 2, 207 University Avenue, Bipenda Patel, manager, failed to ask for identification for the person that was serving as an underage representative, and
Not to be redundant, but if you can introduce yourself for the record, Counselor?
Certainly. Good evening, Brendan McMahon on behalf of Mr. Patel with my
I'm
client.
sorry, could you say your name a little more clearly?
Brendan McMahon.
Thank you.
You're welcome.
Captain Webb?
Mr. Commissioner, excuse me, this was a compliance check conducted by detectives assigned to the Special Investigations Section on May 2nd, 2013. The detectives were assisted by a 20-year-old male during these compliance checks, and the male had no identification or money with him other than the money that had been provided to him by the detectives. 7:33 p.m., the 20-year-old male entered Jerry's Food Store, 207 University Avenue, purchased a 12-pack of Heineken light beer from a female clerk, and he was not asked for any identification. Lieutenant Goldner and Detective Desolitz entered the establishment and ID'd the clerk as Shilpa Hemaraj, and she was advised of the violation.
Thank you. Counselor?
Mr. Patel acknowledges that she did in fact fail to obtain identification. In this case as well, he confirmed with her. He has indicated to me that he has now required everyone to write down what is purchased, what the cost is, and what the date of birth is when they sell alcohol for this one employee. That was something that he did on his own in the interim prior to me discussing with him getting the licensing program connected to his computer that would make sure that the sale of alcohol wouldn't occur.
That employee still employed?
She is. He has done extensive retraining with her, and explained that she's got to identify every single person that comes in, regardless of whether or not they look 40 or 18.
Cliff?
You didn't undertake retraining after the first incident?
Yeah, did you say?
Did you do the recertification, the retraining at the first incident?
Yeah, I did, and I'm going to do more now. If I have to do something, I'm going to do willing to do everything, do training or what.
I'm sorry, just for clarification, once again, I wasn't on the board, but I hope, we're not talking the same clerk from the January. Was Mr. Patel the one who sold underage back on the first one in January?
Actually, when the hearing was held in February
Yeah.
on that complaint,
Yeah,
the incident actually was last summer.
okay,
And being the fact that the commission was without a third member,
understood.
and so Commissioner Occasion, as we now know, could not sit on this particular matter until such time as Commissioner Krieger was appointed, then the commission could proceed with, we had Commissioner Delaney.
Okay,
and
yeah.
Commissioner Krieger sat and was able to hear that complaint from last summer, August or September of 2012, and which was not heard until February. And so,
Who sold during that time in the past summer? Was it a clerk or was it Mr. Patel at that time?
I believe Mr. Patel had a clerk employed
Clark,
It-
yeah.
at the
was
time of that last September
yeah.
incident.
Okay.
One of the clerk.
Getting back to Commissioner Krieger's question then, was retraining, did that happen after that incident?
After that, yeah.
Okay.
Yeah.
Now, was the clerk who sold prior in your employment at that time during your retraining?
Did you fire the clerk?
From the original one back in the summer of
Yes.
2012, yes, that clerk is no longer
All right,
working.
was the clerk who just sold to the underage, was she employed under Mr. Patel prior, last summer? Because she would have went through some retraining.
Yeah,
Yes,
I did
she was.
training, her.
So how in-depth was this retraining, is my question. If this clerk was retrained and then now resold,
No, I'm going to do retrain also again. Right.
Correct.
so I'm not telling you how to run your business, but you have a clerk that was retrained and then sold to an underage minor and still is under your employment.
I did, retraining.
Yeah, I'm worried about that.
I think I'd like to amend the 30 days from now. I'm getting the wave off.
This is separate. It's a separate matter.
All right, so
You wanna
late
add-
in November, when you come back to talk to us, I think you should also talk to us about the retraining.
I'd like to know what you're retraining. I'm worried about this. We have a clerk that sold, you know what I'm getting at here? What was involved in your retraining?
I go by, by internet, one of the, program, right? Then check the all, program, means, check how to check, ID and everything, I don't have a site here, but.
All right.
I also just want to clarify, just for,
Sure.
to alleviate some concerns.
Sure.
I think there might be some language.
I'm having a difficult time understanding Mr. Patel, but I think I got the gist of my question answered, is that, we have a clerk who just sold to an underage minor
Correct.
who was retrained last year.
And that, I think, is the problem. I think the word training is not correct. I think he was trained, I think the clerk that was involved in this instance has only gone through the training once. He gave the training when she became employed,
Okay?
but she was employed after the clerk from the first incident back in 2012. So I don't think this clerk has actually gone through 2 rounds of training. I think it's just been the one. But I'm happy to, and I think it's a good suggestion that we come back in November and provide not just, yes, we've retrained, but specifically what kind of retraining it was. I'm going to speak with my client with respect to finding a certification program that I think would be more appropriate.
I think the board
At
would,
this time.
I think the board would appreciate that.
I'd be happy to do that, and I know my client is happy to do anything to assuage the fears of this commission.
Okay.
I think the other point, of course, is that the employees follow the example of the manager. So the manager must set the example. This is serious, and I think that we need to, I move that we suspend the license for 3 days. 1 day we hold in abeyance, and you've got some dates there?
All right, once again, just for clarification, Commissioner, we are holding 2 days in abeyance.
Okay,
Correct?
I would defer to Law Department Solicitor Regan, but
Yeah.
I would just suggest to the Commissioner, and this is kind of reminiscent of something that the License Commission had dealt with some years back, in which it was like two complaints, two separate matters. I'm not so sure that you've taken action on another complaint just this few minutes back here can necessarily enter into the decision you may wish to make at this time
Concerning the abeyance.
respective to this second complaint.
Attorney Regan, please.
Well, I mean, considering that discipline is supposed to be progressive, each subsequent complaint, whether they're in the same hearing or not, should have an intensification of penalties. At the very least, the second complaint should trigger the day held in abeyance from the first complaint.
Okay,
I'm confused.
Okay,
All right, so
so,
prior complaint, we had 1 day in abeyance, which we served, which the,
which we're triggering.
all right, we're
From
triggering.
the first complaint
We
tonight.
now have 2 days in abeyance,
Mm-hmm.
which you're telling us we can trigger?
Yes.
I'm sorry, we have 2 days in abeyance?
I'm sorry, there's 1 day in abeyance from the February hearing.
Yeah, which we're going to execute.
Right, based
So
on the
that
first
day will no
complaint.
longer be in abeyance, right?
Exactly.
We had 3 days.
But in the first, I'm sorry.
but here's can I just say? Sure. The first decision is subject to appeal to the Alcohol Beverages Control Commission. It's subject to appeal, irrespective of what Attorney McMahon is alluding to right now. Your decision on that first complaint was a 3 days, the first day of, it's the day that was held in abeyance and from the decision of February is to be served. In addition, the motion was to suspend for 3 days, to hold one of those 3 days in abeyance, 2 of the 3 days to be served in conjunction with the first day held in abeyance from February. That decision is subject to appeal to the Alcohol
Right.
Beverages Control Commission. You have now a second complaint, identical problem, issue, complaint. And it would be my understanding from a previous action of the License Commission at this time that this second complaint be separate from anything you may consider doing from what you've just done on the first. It could be identical, but in terms of action, as far as anything that might be appealed on the second complaint, it would be over there, separate. That's my,
So, the
Became-
motion on the floor,
if you would just include a decision you just made as part of your action now on this second complaint, the appeal of, it's a potential appeal,
yeah, I got that.
could be jeopardized. You could jeopardize
Got that.
both decisions.
So the motion on the floor is to 3 days, 1 day in abeyance, which has nothing to do with the first decision. The question is,
Okay.
when will we apply it? And I think that it should be applied so that it follows the previous, so that they don't overlap.
Is this
Overlapping would not be good.
Well, I agree with that.
Attorney Regan, maybe you can help me out here. What Ryan is saying is that, should we just kind of stay away from the abeyance?
No, I'm not saying that.
No, you're not saying that. So why can't we, because we still have days in abeyance from the first complaint,
But that's a separate action on a separate complaint.
okay?
And I'm just suggesting, based on my understanding of what the License Commission had dealt with in
Don't
a
touch the
previous matter,
bans.
totally unrelated to all of this.
I get you.
But it's just that with the this action was appealed to the Alcohol Beverages Control Commission of what I'm alluding to, and at which time the decision which was subject to the License Commission acknowledging it and then accepting it was on a remand to the License Commission that what the commission was attempting to do on a second complaint was to tie in the decision of their suspension on the first complaint. And it was recommendation of the Alcohol Beverages Control Commission that that could not be done that way, the manner in which it was done. All I'm thinking in terms of potential action that you may take now on the second complaint, and what potentially the licensee may consider doing if they wanted to appeal it. I'm just,
So we don't even touch the abeyance, we just, a straight out suspension.
Yeah.
And you can put another day in abeyance. If they do go to
Right.
the ABCC with it, then fine, so be it.
The outcome would be, if we go with 2 and 1, 3 and 1 in abeyance, the outcome would be there are 2 days hanging out there.
Right, and we'll leave them there. We're gonna leave them there. So now your motion is for this?
3 days.
3 days.
1 in abeyance.
All right. And it's the motion
That they
to
run
run, to
sequential.
run concurrent. So if we're
Not
at.
concurrent, yeah,
not
sequential.
Sequential. So if we're at, the first complaint was October, we had a suspension for October 25th, 26th, and 27th. You would want the suspensions
28th, 29th.
28th, 29th?
Yeah,
That was yours, was that a 2-day suspension?
just it would be 28, 28.
2 days, yeah.
Got it, so that's it, all right.
And 2 days out there in abeyance.
I'll second the motion. All in favor?
Yeah,
Aye.
Before we move off this, though, the police department had, as you mentioned on the first item, the violation of number 11, rules, regulations, no license, et cetera. Is that just boilerplate, or was there some specific activity that you're alluding to here, Captain Webb?
On the second
Yeah,
violation charge in the complaint,
yeah.
no, that is, that refers back to the first specific violation. The reason we write the complaint like that is that's been recommended to us by investigators from the Alcoholic Beverage Control Commission, that that's how the complaints be written.
Thank you.
So once again, should we make this clean, Ryan, for the second violation and violation of 204 and place that on file?
I don't think so. I mean, I see it as,
My understanding is that regulation of which the illegality in this instance is the violation of Chapter 138, Section 34.
Right.
I know that the ABC, the Alcohol Beverages Control Commission, will reference their regulation, which is the State Alcohol Beverage Control Commission regulation, as an illegality, and they'll cite chapter and section of the violation, so that it's possible that any procedure that might take place as far as an appeal of the ABC's action, where they could cite that there were 2 instances, a violation of the statute and a violation of their regulation, in terms of any potential appeal that might take place on a decision of the ABC with Superior Court.
I guess the key sentence is, the licensee shall be responsible therefore whether present or not.
Correct.
So the clerk or that, so I can understand that.
but we've acted on that.
We have acted, I'm wondering,
We're taking 2
Attorney
bites
Regan,
of
is
the
that the
apple
right
here.
way to do this, to make this clean? That we should be, Captain Webb, maybe you can help me out here?
The reason they recommend that that's how the complaint be written is, matter of fact, what they've suggested to me is that each complaint should be written as that second complaint is written, and that be included for each violation, because that's technically what the violation is, permitting an illegality,
So it's not
whichever the
138-34.
specific violation might be.
So it's not 138-34, it's this other thing.
No, the motion was selling or delivering an alcoholic beverage, which we did. I'm wondering how legally, I mean, we have 2 complaints here.
The allegation is there's one complaint, the complaint is the licensee failed to, served and sold an alcohol beverage to an underage person.
Correct.
And that's a violation of Chapter 138, Section 34.
Right.
The regulation is to include the fact that as far as state regulation is concerned, there is an illegality, whether the manager was there or not. And the legality is that a minor was sold and served alcohol. So that would be, they're tied together. It's tying the first with the second. And it's not uncommon to do that, and I've seen it a number of times in their
I'm
decisions.
just wondering if we have addressed it.
You've addressed it, you have addressed it.
Fine,
You have addressed it.
fine.
Yep.
Good with that.
Okay.
Mr. Patel, I can't overemphasize to you that the retraining and the ID scanner, we will see you in November, and hopefully everything is right in line. All right?
Yes,
All right, thank you.
Bring photos.
Thank you.
thank you.
Commissioner will now proceed with the hearing on the allegation as charged by Deputy Deborah Friedel, Superintendent. With respect to the package store licensee known as L&M Liquors, 424 Chelmsford Street, Leonia M. Mendonca, manager. And this was a compliance check conducted by Lowell Police Special Investigations on April the 11th.
Introduce yourself for the record, please.
Good evening, Commissioners. My name is Kevin Murphy. I represent Leona and Jose Mendonca. They are the principals of L&M Liquors, Inc., owners of the premises at 424 Chelmsford Street in Lowell, Massachusetts. Identify yourself, please.
Leonia Mendoza.
Alberto Mendoza.
Thank you.
First of all, for the record,
Would you like the complaint read into the record,
we
Counsel?
stipulate to the facts in the police report, and
Yep.
we don't dispute what happened that evening. If I could just address the board for a moment.
Please do.
For my clients, this was the American dream. Husband and wife bought this business on Chelmsford Street. It turned into what I'm sure many of you know is a very, very difficult business, operating a package store in the city of Lowell these days. It's an around-the-clock business. As a matter of fact, one of my clients, Leona, here will tell you that she had to return to a full-time job during the day just to cover her health insurance benefits for the family because they were too expensive to be paid out of the business proceeds. So she works full-time, and then after work, she takes care of her 8-year-old son and does the books at home most of the time. The business is run mostly during the day by her husband, Jose, and his brother, Albert. And we're not going to hide anything from you. You know, we were here some time ago relative to an infraction where we did serve an underage client. And it was Mr. Mendonca who served that person that evening. And in mitigation, I think if you read the report, the night of this incident, which happened in April of this year, approximately 6 months ago, is that Mr. Mendonca would tell you that he was serving the regulars that evening. He's been working there for the longest time as the brother-in-law, and he believed everyone was a regular and everyone had their ID. He had checked their IDs before and didn't need to check the IDs that evening. Unfortunately, he was wrong in this particular case. And when the police came in and confronted him with this, he was upset because we had obviously been very, very stern with him for the previous offense and instructed him that he had to check IDs whenever there was a question, and he believed that he was in the right that evening. And that's why he was upset because he knew this was going to be a very serious thing with his sister-in-law and his brother if he got them in trouble again. Mr. McGuire, tell the police how you feel about what happened that evening and how you behaved.
Well, first I want to apologize for my behavior on that particular day. You guys were just doing your job, and I was wrong. That should have not happened, you know, the way but he just specified more or less what I was thinking. I thought I was right, but I was wrong. And that won't happen again for sure.
So it's been 6 months, and there have been no incidents in the 6 months since this has happened. Mr. Mendonca, who has gone through subsequent training, he originally was trained in tips prior to this incident, but he has had updated training in tips since that infraction. And it must have worked because there's been no incident in the past 6 months. We would love to be able to bring in, I know there are experts in the field that come in and do spot checks on the businesses. We'd love to be able to buy a machine. We'd love to buy one of those swipe machines. Unfortunately, this business is not one of the most lucrative businesses. This isn't a Cappy's or a Martinetti's. This is L&M Liquors on 424 Chempsford Street, and those type of endeavors are very, very costly. We apologize for what happened. We are a very small family-run business trying to do the best we can, and we just ask you to understand that we're very, very sorry for what happened, especially to the police department for any uncooperative attitude that must have happened that evening. It wasn't meant as an affront to the police department, but because Mr. Mendonca knew he had been wrong in the past, and he knew the travails that would happen as a result of his actions. And we've taken all the steps we can. We're going to continue to try and make sure that there are no incidents that occur there, and we are asking you to have not sympathy, but understanding that this is a small business in the city of Lowell, and to shut it down for any extended period of time would be devastating to this family. As we all know, I mean, if you were to come to 424 Chempsford Street, that package store for several days and it's closed, you will seek out another package store on Chempsford Street and will never return. And that will even more seriously impact the Mendonca family. With that said, as I said, we stipulate everything that went on. We don't say we did anything right, but we're taking every step to make sure that we cure any of those deficiencies in the future.
Mrs. Mendonca, how long have you owned the business?
3 years.
Yeah, come up to
I'm sorry.
3 years.
3 years, okay.
Yes.
Ryan, this is the 6 months ago, that was the only incident there at L&M?
Yes.
Actually, excuse me, Mr. Commissioner, there was an incident from 2012 also that was put on file. So there was no penalties served, but there was a previous incident in 2012.
Was that incident placed on file? It was,
We got it.
2012.
So, Ms. Mendonca, what's your understanding then of who does and who does not get ID'd?
When I'm there, I ask for ID. Actually, sometimes they laugh at me. They say, "You're not serious." I do. It doesn't mean that one day I'm going to make a mistake. We do the best we can. Believe me, we don't want to make an error. We don't want no trouble. We just want to run a family and peaceful.
So you understand that
I
you
do understand.
ID everyone?
Yes, we do understand that. We have signs everywhere. Believe me, I'm not happy about this, and I totally apologize for it. And every day we remind everybody, IDs. Me and my husband, we remind everybody, every half an hour, IDs. Again, the only thing I can say, it happened. I am very sorry for what happened.
The incident that was placed on file, who was working that night?
My brother-in-law was.
So this has happened to you twice?
Yes, yes. That's when, after that first one was placed on file, we had him do the TIPS
Yep,
program.
yep.
That was part of the disposition. He did the TIPS program. And then after this incident, he's done the updated TIPS program.
What have you learned with the updated TIPS program, Mr. Mendonça?
Come here, speak in the microphone.
ID is very important. You gotta ID every single person, and don't go just by the visual look. You know what I'm saying? You gotta have an ID, and that's what I'm doing now for the last.
I guess my question to you is that you were TIP certified and then there was a refresher TIP
Yes,
certified.
yes,
Was
yes.
it the same program or was it something that was more enhanced in the program?
Was a little bit different than the first one, but the main thing was that don't serve to minors and don't serve to people under the influence of alcohol.
Cliff? This board is not into ruining people's lives and their businesses. We understand, counsel, and I appreciate this is a small business owner and, you know, working another job, and it's not our intent to put anybody out of business, but I am a little concerned that Mr. Mendonça is now, this has happened to him twice. I'm not sure if the enhanced training is, I hope this has taught you a very valuable lesson, Mr. Mendonça. With that being said, I would make a motion for a one-day suspension that would be held in abeyance, but the day in abeyance that we do have would be served. Okay?
Second.
All in favor?
Aye.
All right.
I just asked that could be on a Monday.
It is not. I think if Mr. Mendonça was here for the first time, I probably would have done that. But now that he's here for the second time, I think what we'll do is we'll make it, we have to do it 2 weeks, right, Ryan? Do we have to do it 2 weeks then?
Sure.
October 24th, which is a Thursday. Anything else?
Thank you very much.
Thank you.
Oh, I'm sorry. We have another hearing, Mr. Cheng Tel, is he here? He's not here. There was a complaint against the licensee known as Compound Tom Market, Inc., doing business as Appleton Liquors at 171 Appleton Street, Cheng Tel manager. This incident took place on May 2nd, 2013. The licensee was notified of the hearing this evening. There's no one present here. I'm assuming he didn't get the message or he didn't get the letter.
I move we kick this down the road 2 weeks and,
Continue to October 24th.
yes. And then if it doesn't show,
Okay.
Anything else, right?
who we adjourn?
Second.